Good afternoon, everyone, and thanks for joining our webinar today. For anybody who doesn't know me, I'm Stacy Lawler, the principal at Our Opinion, and I am really excited to be hosting this webinar in collaboration with Karen Hoffman and our partners at Prudential and our partners over at CAFL. So we are doing this, as some of you may already know, as part of the spirit of Women's History Month and promoting, collaboration not only among female advisors, but also trying to promote working with female clients and giving you guys the tools necessary to help, as our last webinar said, help you create financially fearless females within your practice and strengthen your relationships with your female clients. And today we'll take it a step further than we did last time, where we talked about a lot of statistics and planning for your female clients' retirement and the importance of estate planning for women. So as we did mention last time on our last webinar, if anybody who missed our last webinar, we can either reach out to myself or your partners at CAFL, and we're happy to share a recording of the webinar. But as we did discuss, women today control $10 trillion of assets in the US, which is projected to grow to about 30 trillion over the next few years. So we are controlling more money than ever before, earning more money than ever before, making more money and making more financial decisions, which is really important, and are set up to inherit a lot of money as the baby boomers and the next generation are aging. So estate planning is absolutely crucial for all of your clients, of course, but also for female clients, which are often overlooked in this arena. So we are really excited to be joined again today by Karen Hoffman, Vice President in the Advanced Markets Department of Prudential, to talk about safeguarding their future, the importance of estate planning for women. And we were just talking about a few minutes ago how on our February call, we talked about a lot of statistics to think about the overarching importance of financial planning with your female clients. This will be some really actionable items and strategic planning of estate planning for those women. So thank you again for everybody coming on. And I just want to make sure we mention that this is part of the Women in Finance Roadshow that we're partnering, OWR, CAFL, Prudential are all partnering together to bring to a location hopefully near you. April 30th will be in Doylestown, Pennsylvania, May 1st in Kenilworth, New Jersey, and May 2nd in Albany. So if you have not registered, or if you have female colleagues that you think would benefit from meetings, we'll be doing some networking, collaboration, professional development, and sales ideas and marketing of insurance solutions for your clients. Please reach out to any of us on the call to register and learn more information. So a little housekeeping. Today we'll have everybody, or we're going to ask you guys to mute, and you can always type in questions in the chat box and we'll read them off, or Karen will be happy to open up all the lines afterwards and take questions. But there's a lot of information. I think you'll find the presentation really valuable, but we want to make sure we get through it, and then we'll answer your questions at the end. So without anything else, Karen, I'll pass it over to you.
Yeah, thanks, Stacy. Yes, really well put. The last presentation was sort of the market, the way the market looks, the stats, a lot of statistics that we shared. But this time I put together this particular presentation for one reason. Women are obviously, as you said, going to be inheriting a lot of money in the future. Hopefully I'll be one of those, joking aside. But, working with women in estate planning, it's not just about women. A lot of these strategies that I'm going to cover are going to be talking to couples. But eventually, most of the time, again, statistically, women will be responsible for a majority of their estate in the future. So I had to think hard about what I wanted to do in this presentation, and I put together some particular things that I think important to share with our women clients and share with our couples, because a lot of this planning is done before a spouse passes away. Of course, it's not after this first spouse passes away, but we're going to assume in a lot of these cases that the female of the couple is going to be largely responsible for the rest of what happens to their estate as she survives her husband. Now, that's not assuming she's always going to survive, the husband, but we're going to assume in most cases that she does. So just moving the slide. So it's about the future, right? We know, again, I don't want to share a ton of statistics, but we know women outlive men by about 5 to 10 years, if not longer. The majority of women in their 90s and even past 100, that percentage that survives is greater. And I always like to tell a story of my husband's grandmother who had passed, I think, in her 90s. But I always wondered. She was pretty wealthy. She'd inherited most of her wealth from her parents, and she'd been through multiple husbands. And I always asked her why she never married again late in her life. And she told me, and this is the funniest saying I've never heard from somebody that lived in the South. She said, "I don't want to be a nurse or a purse." And it's stuck in my mind because a lot of times women don't often marry again when they get into their late 70s and 80s, whereas men statistically do marry again depending on when they're widowed, and generally speaking it's to a younger woman. Could be very young or not so young, but we see more women today holding on to these finances in greater quantities than we ever did before. So we really need to help them safeguard their future. So here's what I did. I put this together. As I just said, women are projected to live 6 years longer than men, if not longer. And the gap in life expectancy between men and women is as large as it's ever been in 25 years, right? So I sort of shared that with you already, but they're on their own, right? There are 11.6 million widows in the United States, which is 3 times the amount of men widowers, right? And this was the statistic that I wanted to share. 50% of women age 85 and older live alone, right? So they all need a plan to ensure that they have that financial security and really the protection. It's all about the protection to enjoy those years alone and to share or to leave behind a legacy that's well thought out and well planned for. So why do women need estate planning? Well, everybody needs estate planning. It's not just women, but women in particular, as I said, living alone, they're more vulnerable, I believe. This is really what it's about. They're more vulnerable for various reasons, right? Obviously, managing estate taxes, we'll talk about that, avoiding probate, but it's also about these things, preparing for potential loss of capacity, mentally, maybe not capable, planning for their kids, special needs. But really what it is controlling that asset distribution and protecting against the mismanagement of funds. We hear nightmare stories about elder abuse. I took a course on elder abuse and I was shocked at how prevalent it is for older women. And believe me, believe it or not, most of that elder abuse is from children. But also to ease a transition for their loved ones, right? To make sure that those assets are going to the right people or person in the most tax efficient way. Okay, so this is really what we're going to talk about. So here's where we're going to start with. We're going to start with the basics. What should every woman understand when it comes to leaving behind a legacy? We're going to talk about estate and gift tax exclusion, portability, gifting. And then we're going to kind of get into the 3 things that I particularly find is more important for women than it is for men. We're going to talk about SLATs. We're going to talk about AB trusts, B trust funding, Q-tips, and then we're going to end with standby survivorship trust. And again, all of these things need to be implemented before the first spouse passes away. But most of the time, these last 3 things on this slide usually impact the female the most. All right, so let's just talk about the basics. Every client that we work with, regardless of female or male, should have the basics. The basics of estate planning is a will, Is a trust most likely better than a will? Is a durable power of attorney? They need to be able to give somebody the authority to make legal and financial decisions and medical decisions, right? That's so important, because even if you don't, even if you live longer than a male spouse, there's a good chance that maybe you won't be completely competent, and you need to name somebody to be able to step in on your behalf. Healthcare directive, so important. Provide instructions for medical care in the event that you're incapacitated or you can't make financial or healthcare decisions on your behalf, and obviously other trust planning, which will include tax, right? Estate taxes. So we've seen this 1,000 times. We know what the lifetime gift tax exemption currently is. We know the estate tax exemption and the gift tax exemption is at 13.6, probably going to go up to over 14 million next year, and then sunsets down at the end of 2025 to half, roughly around, we're calculating it to be around 6 million. So planning to use these exemptions is so, so important, and we're really pushing it hard. All of our marketing campaigns are being around about using the exemptions now while you can. And obviously, we don't know what they're going to be in the future. It could be even less depending on any legislative changes, right? So these are 3 exemptions. Then you don't get 3, you get 1. You can either gift it during life, leave it behind at death, or use it to generate dynasty legacy planning, where we use a generation skip and transfer tax exemption to pass assets down to multiple generations. So this, I'm going to spend a little bit more time on this slide for a couple of reasons. Things have changed, and I think most of us don't talk about this enough. And I think with what I just said about the gift tax exclusion or estate tax exclusion going down, this is so important to have this conversation. What am I talking about? I'm talking about portability for spouses. In the past, if you didn't use your lifetime exemption, you pretty much lost it, right? Unless you had some kind of credit shelter trust, which we'll talk about in a second. Most of the time when the first spouse died, the exemption went with them. Back in 2010, they changed the rules and allowed portability for federal estate tax exemption. And what it basically means is a surviving spouse can port over what we call the DSU, deceased spouse unused exemption amount. So when the first spouse dies, the surviving spouse can port that over. And that basically means that they take whatever that deceased spouse didn't use up and move it to themselves. So in this case, husband died with a $3 million estate that he left to his kids, right? So he didn't use all of his estate tax exemption amount. And what she ended up doing was porting over 10 million of his unused amount, added it to her 13 million, and now she's got 24 million. Now, does she need it? Maybe not. Maybe she doesn't have a $24 million estate, but at least she ported it at the time he died, and now that's hers to use, right? When you port an exemption amount over, you get that exemption amount regardless of whatever the estate tax exemption is in the future, right? So the way to do this is that surviving spouse has to file an estate tax return. Even if there's no estate taxes due, she has to elect it on that estate tax return in order to get it. Now, everybody should do it regardless, because why would you lose something that you possibly may need in the future? But here's what happened. That portability, that estate tax return was supposed to be filed within 9 months of the spouse's death, which for a lot of people wasn't enough time. So a few years back, they changed it. The IRS changed it and said you have 2 years to file that estate tax return to get that portability. And then they found that people were still not not having enough time or not knowing that they could do that and losing the ability. So back in 2022, I believe, they changed the rules again. They said that you have 5 years from the death to port it. So if you missed it in year 1, 2, 3, and 4, you have 5 years to still do it. So again, I would encourage any advisors that have widows that didn't do that porting. Of course, they've got 5 years from death to do that porting regardless. So it's really important that we have a conversation to our clients about using that, because I think it's so very important not to lose it. The other thing that we don't think about when it comes to estate taxes is state death taxes, right? Look at how many states currently have a state estate tax. Various exemption levels. Connecticut just changed theirs to the federal level. They were lower than that prior to a couple of years ago. But most, if you look at states like Oregon, if you look at states like Rhode Island, look at states like Washington, all of those have really low exemption levels. So even though the estate tax rate isn't as high as the federal level at 40%, there's still a good, there's still a good tax that's due on not only people that live in those states, but also perhaps have property in those states. If you have real property in those states, you're subject to an estate tax in that state. And then if you look on the other side of the screen, some states have what they call an inheritance tax. Now, what's the difference between the two? The difference between the two is state is just a flat, state estate tax. But an inheritance tax, and some of you may live on the West Coast, some of you may be covering the West Coast, New Jersey and Pennsylvania, for example, they have pretty high inheritance tax. And it means that whoever inherits those assets pay an inheritance tax. Now, normally it's not a spouse. Those are usually exempt from inheritance taxes, but it normally applies to other relatives, children, nieces, nephews, mothers, brothers, sisters. Depending on what relation you have with the person that's passed away, you could possibly pay quite a high inheritance tax on those assets. So if you have clients in any of these states, the conversation needs to be had about what possibly they would inherit and the tax consequences. So the question is, well, how do I reduce my future estate tax exposure? Well, there's a couple of ways to do it. You give it away during life, you give it to your family, you move it out of your estate using trusts, or you give it to charity, right? So that's really the only way that you can unexpose yourself to future estate taxes, is a dollar for dollar reduction by moving it out of your estate, either by uses of trusts or giving it to kids and family, right? It also removes that future appreciation from the estate. Once you've moved that asset out, you're going to remove all growth on that asset. The question is, who do you want to leave the money to, right? If you have a fairly sizable estate, and when I say fairly sizable, I'm going to say, I get this question all the time, anybody that's worth over $10 million, right? If you have a sizable estate, there's 3 places that this money's going to go. It's either going to go to your kids, if done correctly, it's either going to go to charity, if done correctly, or it's going to be the IRS. So the question is, which one do you want the kids to write a check to, right? Also, by removing some of these assets, you keep the assets intact, right? Because if you don't remove these assets and do some planning with these assets, a lot of times those assets have to be sold to pay the estate tax bill. And lots of times those assets have to be sold at a discount or a fire sale, we call it. A lot of times people want to preserve a family business. A lot of clients that have businesses, especially family business, they want to keep it in the family. If they have farmland, if they have, illiquid assets, it's really difficult to come up with, the money in 9 months when the estate tax is due. So a lot of times we use life insurance to protect those assets and to make the liquidity available so the kids or the grandkids don't have to sell those assets. And of course, we're going to get into leverage gifting, If you have clients that are gifting to remove assets from their estate, you need to talk to them about leveraging those gifts, right? What do I mean by that? If you're going to give it away and you're going to have no way of bringing it back into your estate, why would you not take advantage of leveraging those gifts with life insurance? Now that gift is not worth $1, it's worth $100, right? So leaving more to the kids and the grandkids. So let's talk about that. Let's just look at an example. Let's just say I've got a married couple and they're worth, 20 million plus. And there's two things that they could do. They could remove the whole 20 million from their estate, which is probably not what they're going to want to do, because why would you give away everything? A lot of times clients are like, nah, not sure. I'm not going to, even though I think it's a good idea, this isn't something I'm going to want to do. But a lot of times clients use their annual exclusion gifts instead. What am I talking about? Annual exclusion gifts is $18,000 a year to as many people as I wish. So in this particular example, I'm assuming that this married couple has 6 grandkids. And instead of getting rid of the whole $20 million of their estate, leaving them nothing, right? We give away 18,000 times 6 every single year. And if you look at the numbers, by doing that, yes, it's saving them some estate tax, less than the 20 million, but it's still worth it in terms of estate tax savings. So a $20 million gift would save them about 13 million in estate taxes versus about 1.5 million by doing the annual exclusion gifts. So why am I talking about this? I'm talking about this because if you've got clients that are deciding to start gifting for whatever reason, they want to remove assets from their estate, they want to see the grandkids enjoy those assets or the kids, let's just say instead of giving a direct gift to a child or a grandchild, we use 108,000 annual exclusion gifts, saving them some money in estate taxes. But this time, instead of giving it to them directly, we put it in a life insurance policy, a survivorship life insurance policy for $108,000 a year for 20 years. Right? We do a 20-year pay life insurance policy. Look at what the leverage that gives them. That $108,000 a year, in this particular case, 60 male, female, preferred non-tobacco, survivorship policy would give them a death benefit of close to $8 million, right? So instead of the kids getting $108,000 a year or $18,000 each, they end up at the end of mom and dad's life with close to $8 million tax-free. That's the power of leveraging. And in fact, if we took that $108,000 a year for 20 years, we'd have to earn about 5.6% every single year, assuming that couple both died at age 91. So that's a really good internal rate of return by leveraging any gifts. So now let's get into trusts, right? Obviously, we've got revocable trusts, which have no tax benefits. I have one. Many people have one. I love trusts. I love living trusts. I think they're great, better than wills. But normally, when a client is trying to remove assets from their estate, they're going to be looking at irrevocable trusts. And there are many different forms, and we're going to get into that, right? So when you've got clients that have substantial assets and they're looking at life insurance, obviously you're going to want to use an ILIT to remove the life insurance from their estate, because if they don't do that, they've just added the life insurance into their estate tax bill, right? So using an ILIT, make sure that the insurance policy is still income and estate tax free, removes it from their estate. Client's attorney drafts the trust, the clients gift the premium to the trust, any money's going in is a gift to the trust. The ILIT purchases a policy on the client's life. Upon death, the death benefit is paid to the ILIT, and then the ILIT can use any of those death benefits to pay the trust beneficiaries, who in turn now pay the IRS for any estate taxes due. Pretty simple, right? But here's what's not simple. A lot of clients are not ready to do ILIT planning. They fear losing control over the assets. They have no access to the assets in the trust. It's pretty much gone. What if I need it? What if something happens? right? A lot of times that's going to be one of the major concerns of not doing an ILIT, right? So one of the things that, and this isn't new, this has been around since the 80s, right? One of the things that we do is we say to a client, look, there are other ways to do the same planning with more flexibility and more access, right? So would they be interested in still doing an ILIT, still using a life insurance policy to fund it, but instead of not having access to the assets in the ILIT, not having access to the cash value in the policy, one of the spouses has indirect access to anything in that ILIT, right? Would they be interested in doing that? And in fact, I talk to a lot of estate planning attorneys, and they say that they do more of this type of planning than the old type of ILIT planning, because a lot of clients love the flexibility of being able to, if they need it, they can have it, right? So what am I talking about here? I'm talking about a SLAT, a spousal lifetime access trust. And this, again, we're talking about women in estate planning. Normally, when we're talking about this type of estate planning, that's the female, the one that has the longer life expectancy, that really benefits from doing a SLAT. So a conversation with both of them in the beginning, but usually she's the one that benefits. So what is a SLAT? It's an ILIT. It's drafted as an ILIT, but it's drafted a little differently, where one of the spouses is the beneficiary of the trust and the other spouse is the grantor, instead of the normal ILIT where they're both grantors. So one is a beneficiary, one is a grantor. That's how it works. That's how this whole thing gives access to one of the spouses, right? And because we have a trustee that's independent, the trustee can make distributions from the cash value in the policy, from whatever money's inside of the SLAT, to the spouse as beneficiary, right? So the spouse has access to the money. Now, you say, well, one spouse has access, but the other spouse doesn't have access. Well, it's okay if they have a good, stable marriage. Does it matter? If that's a problem, we can do two SLATs, one on each, where one has access to the other one and the other one has access to the other. But generally speaking, we just use one SLAT, giving one spouse the access to the cash in the trust, which is fine by them, right? 90% of the time we use a second to die, because as we know, the estate tax isn't due until the second death, right? So here's how we set this up. We make one of the spouses, typically the older one, doesn't have to be the husband, it could be the other way around. But in this case, we make the husband the grantor. The husband is the gifter of the premium, meaning only the husband can make gifts to the trust. The SLAT uses a third-party trustee. Why do we use a third-party trustee? It doesn't have to be a trust company. It can be a friend, a family member, somebody that has no beneficial interest in the trust can be an independent trustee. And the reason why we're doing that is because we've got both insureds. Both of these guys are insured, so we don't want to have any incidents of ownership bringing the policy back into their estate. So while the grantor gives premium from, in this case, his separate assets, the non-grantor spouse, the wife, has access to whatever's in the trust. And so anytime that they feel like they need money for any reason whatsoever, the trustee can distribute assets to the non-grantor spouse, the wife, right? And then after she passes away, if we still have the trust intact, the children have access. But usually once she passes away, it's kind of done, right? So this is like the best of both worlds when it comes to irrevocable trust planning. In my opinion, it's great. Now, the only downside is some rules. The non-grantor spouse cannot be the grantor, cannot be a trustee, and that non-grantor spouse cannot make contributions to the ILIT. So the question always comes up, and I know I may get this question, well, Karen, what about community property estates? How does that work? In community property estates, the attorney can do what they call transmute some kind of property, some kind of asset into separate property. So there's one extra step that they do, right? They transmute, they use a post-nuptial agreement of some kind, or even use assets that were always going to be the grantor spouse's asset, could be a gift or something like that, which is never community property, right? But the other thing is, well, what if the non-spouse or the non-grantor spouse dies first, right? Well, now what happens, right? What if the grantor spouse dies first? Who's going to pay those remaining premiums? So in this case, you've got to set up some contingency plans. If we're worried about the grantor spouse dying first, maybe overfund the trust with assets. So there's money in the trust to pay premiums. Short pay the policy as much as you can, 10 pay it possibly. Use a term policy for a period of time inside the trust to pay those remaining premiums, or have some kind of testamentary trust on the grantor spouse where it's funded immediately at his death, so there's extra money inside of the trust, right? So there's ways around it. It's not the end of the world, but you still need to consider all of these things. So let's move into AB trust. Now, this is really a huge overlooked area for estate planning, especially when we're talking about females. A lot of times, clients have done AB trust planning many, many years ago before the portability option was available. And a lot of these AB trusts were set up with an A trust and a B trust. And initially, it's just a trust. It doesn't become an AB trust until the death of the first spouse. Once the death of the first spouse occurs, the two trusts are now set up. A, and I use this word above ground, B, below ground. The A is the trust for the surviving spouse. The trust assets are exempt from federal estate tax because of unlimited marital deduction, right? So they don't become subject to estate tax until the remaining spouse passes away. So in the beginning, nothing happens. The B trust is created, and usually it's created to fund the exclusion amount, but now it doesn't have to be done that way. But a lot of older trusts still say it has to be funded with an amount equal to the exclusion amount. So one of the things that I've been telling people to do is advise their clients, if they've got old AB trust, to get an attorney to look at this and make sure it's done right. It doesn't have to fund the B trust if it's not necessary. I have an AB trust. My trust says my spouse could fund a B trust if he wanted to, depending on the exclusion amount at the time, doesn't have to. A lot of older AB trusts say they have to fund, right? So you might want to get those looked at and maybe get those changed. But here's really where it comes into play at the death of the second spouse. The death of the second spouse, all assets in the A trust go to the surviving spouse. All assets in the B trust are now irrevocable. That B trust immediately becomes irrevocable. And they're not included in the surviving spouse's estate for estate tax purposes. But here's what happens. They don't get a step up in basis. And any asset inside of that B trust now generates income taxes at trust tax rates. This is such a huge opportunity for us to look at the B trust. Ask, do you have clients with B trusts? Most advisors will tell you they do. I have a lot of B trusts sitting there doing absolutely nothing but kicking out a tax, a taxable, I'm trying to find the word. They're creating taxes on assets that the surviving spouse doesn't need or doesn't use. And there are so many opportunities with AB trusts, it's not even funny, right? I'm going to get into using life insurance in AB trusts in a second, but I just want to very, very quickly mention one other thing. Q-tip trusts. Q-tip trusts are used very similarly to AB trusts, but what they really do is they make sure that if you've got clients that are on second or third marriages, they've got kids from other marriages, that they want to make sure that the kids from another marriage get ultimately, it benefits the surviving spouse while she's alive, but ultimately goes to the beneficiaries of whoever wants it to go to. So if I've got children from another marriage, I want to take care of my surviving spouse, but I don't want my surviving spouse to get the assets ultimately. I want to make sure that the kids get it. I would use similar to an AB trust, an AQ-TIP trust, right? So it just says that, hey, upon the death of surviving spouse, those remaining assets, she can use them while she's alive, but the remaining assets pass to my kids from another marriage, right? So I just want to sort of put that in there. But let's get back into B trust taxation. As I said, the beneficiary is usually a surviving spouse. The death of the surviving spouse, there's no estate tax in that B trust because that B trust is irrevocable. Assets then will be distributed according to the wishes to the couple's children or grandchildren. But the real bad downside is all of those assets, the millions of dollars that are sitting in that B trust, are all subject to income tax. And if any of you know this, income tax in trusts, it's $13,000 worth of income is taxed at the highest 37% rate. So it's really a tax bomb. B trusts are an absolute tax bomb. A lot of B trust advisors don't even think about it. They don't really, talk to their clients that have B trusts, their surviving spouses. They don't talk to them about the taxation, and they just, hey, it is what it is. I'll invest the assets. So a lot of times we need to sit down and say to the client, let's avoid these taxes. Let's use a tax-free asset, a tax-friendly asset inside of this B trust. And maybe we could look at leveraging that asset inside the B trust. So how do we do this? We used life insurance in the B trust. We take whatever asset is in the B trust if the surviving spouse doesn't need the income, okay? Usually you'll find they don't. Usually you find they're living off the A trust and they don't need the income from the B trust. And they're interested in passing this on in the most tax efficient way and leveraging it with life insurance. In this particular case, we take some of the money or all of the money inside the B trust if she doesn't need it, and we own and purchase a life insurance policy on the surviving spouse. What have we just done? We've cut out the taxes. The income taxes completely are gone. And now we've used that $1 million or $500,000 or whatever it is inside that B trust, and we've now leveraged it up into millions. And remember, I said the B trust doesn't get a step up in basis. So we've avoided that. Okay. We've changed taxable assets into tax-free assets. So now the kids and the grandkids inherit a larger amount tax-free. I cannot emphasize how important this discussion is with clients that have B trusts. I just don't think it's talked about enough. Now, there's a couple of things that you have to be careful with. A lot of times the spouse, the surviving spouse, is the trustee of the B trust, right? That's just the way it was set up, just the way it's done. If we're going to use this approach, if we're going to leverage B trust assets, one, to avoid taxes, and two, to give the kids and the grandkids more, we have to make sure that that life insurance policy is not included in her estate. So if the surviving spouse is the trustee, which is most of the time, she will have to resign as trustee prior to the purchase of the policy. Now, normally there's a successor trustee named in the trust, or we just name another, she just resigns and names another trustee. So if you're going to use this approach, if you're going to have a conversation with a client about using B trust assets to purchase life insurance, make sure we consult with the attorney and make sure that she does not serve as trustee and she resigns and names somebody else. So I kind of said this already, right? It allows the insured spouse to increase the amount of money passing to the kids on a tax-free basis. Okay, it enables the insured to acquire life insurance outside of her estate without using any gifting. It reduces the trust income taxes. It still allows the trustee to access policy cash values. Again, she cannot be the trustee if we're insuring her life. And of course, the death benefit proceeds are used to help offset offset any estate tax costs at the second death. Another method is what we call the Standby Survivorship Trust, SST. What is a Standby Survivorship Trust? Basically what it is a way of couples to plan for potential estate taxes in the future at the death of the second spouse, but not using any irrevocable trusts. So what we do is we work this around their revocable trust, right? So the client says, I'm not doing anything irrevocably. I don't know what the future is going to be. I don't have an estate tax problem right now. But I'd like to plan for it just in case. So what we do is we use a second to die policy on both spouses while they're alive. We name one of the spouses, usually the older one, maybe the male, because we think the female is going to live a little bit longer. And we name, let's say, him, the owner of the second to die policy. And then we name their revocable trust as contingent owner on the policy. This is really, really great, flexible way of planning for future needs. So while they're both still alive, they have complete flexibility. They can access the income. There's no irrevocable. There's no anything can be changed, and everything can be changed. But upon that first death, assuming he dies first, the policy now is transferred into their revocable trust, into their B trust. We've named the contingent owner the B trust, or it goes into the B trust. Now, remember in the few slides before this, the B trust becomes irrevocable at the first death. So all of a sudden, the second to die policy is now automatically owned by the B trust, which is now irrevocable. So the only thing that's included in her estate when he dies first is the cash value. So now we've done what we wanted to do. We've done the wealth transfer planning that we wanted to do, but we haven't done it irrevocably while they're alive. It only becomes irrevocable at that first death. Now, again, well, what if one spouse, he doesn't die first? What if she dies first? Well, if she dies first, then we've got to look at it. Okay, well, now we're going to set up an ILIT, and now we're going to transfer the policy into the ILIT at that time. We've got the 3-year look back. We have to be careful with that, but that's probably the only way we're going to remove it from their estate. If we need to remove it from their estate, we got to look at it at the time, right? So there are ways to do this, and protecting both of them. So if it doesn't work the way we planned it, then plan B is just to move it to an ILIT at the time, only if we need to. So here's a couple of examples. I'm at 45 minutes. I don't want to take too much time, but hey, look, their estate is between 5 and 10 million. They're in their 40s, right? They don't know what's going to happen. They don't know what's going to happen to estate taxes. They know that their estate's going to grow. They're in their 40s. This is a typical couple that says, hey, I'd like to plan for the future, but I don't want to do anything irrevocably, right? So I like the idea of the Standby Survivorship Trust. They want to retain control, but they still want to plan for possibly having that estate tax in the future. This is a really good strategy for couples in their 40s and 50s, right? And here's just a slide that just says what I just said, right? This is how it works. Survivorship policy is purchased in his name only. They're both the insured. They create a revocable living trust or even a testamentary trust. It doesn't, it could be either one, but it's got to become irrevocable at the first death. And that way the policy now automatically is owned by that irrevocable trust at that first death. Okay. There's other strategies, especially for females, if they are going to inherit everything. There's things called floating spouse provisions that could be written into trusts that say, hey, the spouse I'm married to today, what if I get divorced? If I remarry, any other spouse is going to be spouse for trust provisions. There's things like trust protector provisions that says, hey, let's put a trust protector on the trust that gives her some extra protection. So a trust protector can come in and, change some provisions. There's things like dynasty provisions where these trusts go on for multiple generations. And of course, let's not forget, if you're working with clients with special needs, we can also put those in. So there's a lot of flexibility in designs of trusts. They're not just one size fits all. There can be a lot of things that clients can write into trusts to make them a little bit more flexible. All right, so I'm just going to sort of end here, right? This isn't just for women. This is helping women ensure that whatever life throws their way, right, they're protected during their life and beyond. Of course, all of these strategies can help financially care for women in the event of their death of their first spouse, and obviously leaving behind a legacy. And let's not forget the tax benefits of using life insurance and the tax benefits of using trust to make sure that when she goes, everything goes the way she wants it to be. All right, I'm going to stop there, Stacy. Stop sharing. Well, I'll stop sharing my screen and I think I'll come on camera for you. Not that that picture is anything like what I really look like. I'm sure I can't start video. There we go. Using the wrong button. Why I can't? Oh, there we go. Yeah. Lot nicer picture. I'm in a funny mood today.
That's my hesitation with the picture, because all I can do is set you up for disappointment.
Thank you. I know it's like here I'm going to disappoint everybody on this call right now. Hey.
I guess first, Juniper, did anybody type in any questions for us?
We did not have any questions.
Okay, well, if anybody has questions, now is a great time to unmute and ask them. And if not, I can kind of cue us a little bit here.
And I'll send this over to you, Stacy. Juniper, just it's a really great deck. I think it's got a lot of good information. It's the usual stuff, but sort of packaged in one nice compact deck, right?
Yeah, and I think, it's so timely in that with the prospect of the sunset coming up. So estate planning and estate taxes are certainly a more and more of a topic of conversation, even if they, aren't impacting a huge amount of population, but it's out there and people are ready to talk about it. So these are, I think, very, client-friendly tips on how it's a little bit more encompassing than just those highest net worth clients. It's also, we talked last time about how women, and I think we had this conversation on this call, but maybe it was separate. Often advisors, some of the feedback I got was advisors feel like they can, or financial professionals may be talking to a couple, but if the woman is less vocal for all of, the confidence reasons we talked about, she's then feeling a little bit left out, or the financial professional often stops talking to her. Well, estate planning and using some of these techniques is a great way to bring her back into the conversation and let her know that you are planning for both of them. Yeah. So I do see a couple of hands raised, so I'll get to them and then I can follow up. So Regina, I think your hand went up first.
It did. There's so much information that you shared. I would need to review it more than time to absorb everything.
Right.
It was recorded, correct?
Yeah.
Wonderful. And we'll have access to review it and go over the recording, because that's something I could go over 2 and 3 times. There's so much.
Yeah.
Excellent. So thank you for sharing so much of that.
Yeah. I like I said, I put this together and I had to come up with if I was a female, I am a female. If I was a surviving female, I'd want to learn all this before it happens, right? I'd want to know what options I have before it happens. Doing all of this planning after my spouse has passed away is pointless, right?
Right.
Yeah. So I totally, Regina, I really agree with you. I think most women don't have any understanding of this at all.
No,
Yeah.
and the other thing and it is because we do live in a man's world.
Yeah. Yeah.
So I don't know whether it will ever change, but it is strongly a man's world. So I think it's important to educate women in today's world, and even the very young ones. I have a 19-year-old, to
Yeah.
educate them on how important it is to know what is going on with
And
this.
what's going to happen when you lose your
Right.
spouse? Yeah.
Absolutely.
Yeah.
Thank you
think-
for sharing.
You're welcome.
RC, I see your hands up too, if you want to go ahead.
Hi, good afternoon. Thank you so much, ladies, for the awesome presentation. My question is, what sort of life insurance policy is that you guys were discussing, and what company actually issues those types of policies?
So most of the time when you're talking about estate planning, you're going to use a survivorship second to die. One, it's cheaper, easier to issue, especially if one of the spouses has got a little health issue. And of course, as we know, there's no estate tax due until the second spouse passes away. So almost all of the time we use second to die, and I'm not going to plug Prudential, but I am. We're probably one of the biggest providers of second to die and the most competitive second to die in the market. Most people come to us for second to die because we've got amazing second to die policies. It's really our forte.
Great, thank you.
And it is available in the state of New York.
Yeah.
For all of those on the call, so
Yeah.
that's who that is relevant to.
Yeah. Yeah, thank goodness.
So that B trust idea, I mean, I think is something really quick. People can go back and think about their clients who may have set up B trust. Two quick questions on that we may want to highlight. When I know, so it's still being set up today, but presumably they were I guess the question is like, what age group, when were those the most popular? So what is it?
So great question. I know exactly where you're going.
Mhm.
Most of those old B trusts, the old AB trusts, were set up before 2010, before portability, right? Because once we had portability, we didn't need to do it anymore, right? I have an AB trust, but that's normally how it's set up. But those older B trusts made the surviving spouse fund the B trust with the exclusion amount. Now, remember, the exclusion amount was 600,000, $1 million, 2 million, 3 million, right? It was never 13 million like it is today. So you're going to find there are so many B trusts sitting out there, Stacy, with $1 million in them doing nothing. $600,000 doing nothing. 2 million doing nothing. They're sitting there. They're a tax bomb, right? There's no step up in basis on those assets. So whoever inherits those assets is going to pay huge amount of capital gains when they inherit. The surviving spouse is living off the A trust and just sits there. And every time I ask an advisor, how many clients do you have on your books that have B trusts? They always say, oh yeah, I've got a few.
Yeah.
And all they do is invest the assets into mutual funds, stocks, bonds, not even realizing they're creating unnecessary taxes for that client. But as I said, you got to be careful. If we're going to insure her life, it doesn't have to be everything inside of the trust. It could be some of it. It doesn't have to be the whole thing. She cannot be the trustee.
Now, if she is 80 and has a
Mhm.
trust and not so insurable, but you want to stop the taxes, and estate taxes aren't a big problem, can you insure her kid to stop the taxation?
Yes.
And let it
Yes.
grow?
Yes. Absolutely. Yeah. If she can't do it, then do the kids.
Yeah.
Yeah. Good suggestion. Yeah. Or, use an annuity, tax deferred, use tax-free bonds. Not great. Can work. Yeah.
All right. Well, thank you. Thank you again so much, Karen. As
Yep.
you heard from Vivek, I think it was a great presentation.
Thank
A
you.
lot for all of us to think about and start implementing and reaching out to clients about. We will record it and happy to share that out. Again, you've heard us allude to the February webinar that Karen also did for us, and we are happy to share that presentation as well for anybody who might have missed it or just wants to hear it again. And for all of you women on the call, we really hope you'll join us at an in-person meeting to hear some, techniques like this and more, and some collaboration with, your peers in the industry. And men on the call, again, we will do something for you soon. We love in-person meetings. So any females in your office, we're happy to include them as well. So reach out to myself or your partners at CAFL or anyone at the OWR office, and we're happy to get you all set up. So with that, if there's no more questions, I hope you
Thanks.
enjoy the rest of your afternoon.
Thanks, guys. Thank you.